Hello, everyone, and welcome to One Civil Law. I hope you are having a great day, and we are here with a brief discussion of the Georgia shooting in the ongoing case of the shooting of Ahmaud Arbery. This recently happened. There is a 36-second video of the shooting, which has been making the rounds, and I wanted to talk a little bit about my legal analysis of it because I recently heard a legal stream with Viva Fry and Robert Barnes, and I disagreed with Mr. Barnes' legal analysis. So I want to present my own legal analysis of this issue and present why I think that this is some kind of version of homicide. What version it is, yet to be determined, of course. And of course, as always, we can only know the full facts as they get developed at a trial. But let's discuss what we know so far based on the video and based on what we have on the record so far. So we have two men, a father-son duo, Gregory McMichael and Travis McMichael. They're 64 and 34 respectively. They are the people that are involved in the shooting, and they shot this individual, Ahmaud Arbery, who is 25, who was out and on a jog, or so it's said. We know from prior video that we've seen this 25-year-old individual inside construction sites. For what purpose is unclear, but we have video of him going on the construction sites, and we have video of him running down the road. So in the video in question, what we see is there's a camera from behind on some kind of vehicle. Who this individual is and why they're doing this, it's a little unclear why that individual is. The person who caught that video's name is William Bryan. What his relationship is, why he happened to be there, a little unclear, but he captured the video. And what we see is Ahmaud Arbery running down the street towards a parked car that's in the middle of the street with two individuals on it. One individual on the car and one individual outside the car, and the individual outside the car has a shotgun. We then see Ahmaud Arbery running on towards the right side of the vehicle and then circling left. He appears to physically confront the individual with the shotgun. The video is horrible. It's very unclear to see exactly what's happening, but there's some sort of physical confrontation. A shot happens off screen, and then that's the end of the incident. The person falls to the ground. So what do I think about this? Well, first thing first, we have two private individuals. I know one of them is a former law enforcement officer, but former law enforcement officer, while it gets you certain rights to carry a firearm concealed in certain situations you wouldn't otherwise be able to, doesn't give you any additional power to arrest. So as far as the power to arrest goes, they're just private citizens, former law enforcement or not. And so the first thing is, did they have the authority to try to detain Ahmaud Arbery? And to look to that issue, we're trying to figure out whether or not they might have been engaged in a lawful citizen's arrest. As to that, we can look to Georgia law and how citizen's arrest is defined. This is Georgia Code section 17460, if you want to look it up for yourself. Grounds for arrest, which states, a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So to me, the first thing that pops out in my analysis of the citizen's arrest statute is that the offense in question for which you're committing a citizen's arrest, the offense has to be in your person or with your immediate knowledge. So it has to be relating to something that is ongoing right now. So the way I would read that statute is you either see it yourself or, for example, someone says, that person has my purse, and you see them running down the street. So that would qualify as immediate knowledge. You didn't see the theft of the purse happen, but you heard someone say, that person stole my purse, and so that would give you immediate knowledge. You were seeing the crime ongoing. It is happening before your eyes. So when I look to the offense being in your presence or with your immediate knowledge, that word immediate to me means the crime is immediate, meaning it has happening or has just happened. The shoplifter has run out the door. The guard says, stop that person, he's stolen something, or the shopkeeper says, stop that person, he's stolen something. That would be the kind of thing that it's triggering to my mind when it's giving you that either you observed it in your presence or with immediate knowledge. So first thing here where I don't think that this works is even assuming Ahmaud Arbery was committing a crime by going onto these construction sites, which I don't grant that premise. But even assuming that was a crime, the crime in question did not happen in the presence or the immediate knowledge of the people who were attempting to detain him. So, assuming these two individuals on the truck were attempting to conduct a citizen's arrest, assuming that was their goal, they didn't have the grounds to conduct a citizen's arrest. Because assuming that him going onto the construction site was a violation of law, they didn't personally see it. It didn't get immediately reported to them. It wasn't something that was imminent. It related to something that happened in the past. And to that, citizen's arrest will not do. You can only conduct a citizen's arrest for something that is occurring in your presence or with immediate knowledge. And that right there, to me, is a no-go. The second thing that strikes me as this is that if the offense is a felony, so again, assuming that this offense is a felony, which I don't think it is, and the offender is attempting to escape or attempting to escape, you may arrest him upon a reasonable and probable grounds of suspicion. The case law is fairly clear, and being a former law enforcement officer, he would know this, that you can't shoot a felon for attempting to escape or in order to stop a felon. That is considered a unauthorized use of force. It's considered to shoot someone is considered legally a seizure within the meaning of the Fourth Amendment. You're seizing someone by shooting them. And the Supreme Court has previously ruled that you cannot shoot someone in order to prevent them from escaping as it relates to an ongoing felony. You can't do that. You have to use other means. So that is not a proper use of force. And so the use of a shotgun here would be, in my view, excess force, even if you had the right to arrest, which I don't think you did. So what kind of crime was being committed? Unclear, if any. When I was a kid, I liked going onto construction sites quite frequently because I'm curious. And I liked to see how they were being built. I liked looking at it and liked seeing how things were being done. When I was a young child, my family moved into a brand new subdivision. And so I got to see pretty much every house around me being built. And then across the street or across the highway, if you like, there was another subdivision that got built while I lived there. So I got to see lots and lots and lots of houses built. And I went on to lots of construction sites because I thought they were cool. And I like to look around them and just to see what was going on. So just a natural curiosity. It's not someone's home because it's not being constructed. No one lives there. So I don't think it counts as burglary. It might be trespass, potentially, but I don't remember seeing any signs when I was young. And unless it was posted, I don't think merely going onto a construction site to look around qualifies as a criminal trespass. Again, does it qualify as a civil trespass under civil law? It's someone's property. Someone has the right to exclude. So it qualifies as a civil trespass. But in terms of being a criminal trespass, there's nothing obvious there that unless it's posted, unless there's something there, it doesn't strike me as obvious that it qualifies as criminal trespass. It's not burglary because no one's living there. And even if it is those things, again, it's not being conducted in the immediate present. So even if he is guilty of some crime, and it's not obvious to me he is, then they wouldn't have the ability to arrest as far as the citizen's arrest unless it occurred immediately within their presence. So I don't think the citizen's arrest was proper. All right. So then we see Ahmaud Arbery run on the right-hand side of the vehicle and then come around. The person with the shotgun standing on the left, this person is running on the right. He comes on the way I saw the video, and the video is horrible. I mean, just in terms of the quality, not in terms of its graphic. It's just very hard to see what's going on. But the way I saw it, that Arbery was coming on the right-hand side of the vehicle, coming around and confronting the person with the shotgun. All right, so what about that? Well, self-defense law would seem to apply. If you're using lethal force against me, I have the right to use force against you. Lethal or non-lethal is my choice. But I obviously have the right to confront you if I want to. So I can choose to engage if I wish or not. It's up to me. I could run away. I can engage. I have the right of self-defense. And Georgia is a stand your ground law, a stand your ground state. I am under no obligation to retreat. So if you confront me with a shotgun and you're threatening me with a shotgun, as far as the self-defense law goes, I have every right to run up into your space and try to disarm you. Now, whether or not that's a good idea is a whole nother set of considerations. We're talking about law, not practicality. So you have the right to do that if you want. So this person is running down the street, jogging, maybe he's fleeing. He sees someone with a shotgun. There's no valid self-defense law, and self-defense. There's no valid citizen's arrest that I can see. No valid citizen's arrest, and he chooses to engage that with his self-defense. Okay, so now he's engaged in self-defense, and this is the part of the analysis where Robert Barnes and I really split on the legal analysis. This is the part where I think he got it wrong. Robert Barnes suggests that in the attempt to reach for the gun, that qualifies as being armed. That under Georgia law, when you are reaching for a firearm, that qualifies as being armed. Now, that part might be true, but it doesn't lead to the conclusion that he does, because you can't engage in self-defense for an incident that you started, and this is a very well-established law, right? So I'll give you a clear hypothetical. I come up to you, you're standing on the street corner, right? You're doing absolutely nothing wrong, you're standing on the street corner. I present a firearm, I say, give me your money. You choose to engage me, all right? Let's say you take my firearm from me, okay? I say, whoa, wait a second. He took my firearm from me. As it happens, I'm a smart armed robber, though. So I have a backup gun. So now that you're armed, I pull out my gun and I shoot you. Can I do that self-defense? Absolutely not. Because the self-defense that is occurring is as a result of an incident that I started. I can't take advantage of self-defense in an incident that I initiated. Self-defense only exists as a result of a situation that you don't initiate. So in this situation, these people have a shotgun. Ahmaud Arbery comes up and is trying to take the shotgun. So that makes him an armed person, right? So now he's armed. And they say, oh, and so these two white guys who shot him, these two individuals who shot him, say, oh, I have a right of self-defense. No, you absolutely don't. You absolutely don't, because you are the one who initiated the situation. You can't take advantage of a self-defense situation that you initiate. And for what it's worth, there's this whole escalation doctrine. So you can't start a situation and then someone escalate and then you escalate and you escalate. That's not what that works. So that's not going to fly. So even if he was attempting, so this is where I don't think, even if Ahmaud Arbery was reaching for the gun, and Robert Barnes again suggested maybe Ahmaud Arbery was the one who actually pulled the trigger and wound up shooting himself. Even if he wound up pulling the trigger, even if he wound up shooting himself, I don't think it matters. I don't think it matters under the law, because the person who created the situation in the first place, these two individuals with the shotgun, bear the burden of everything that follows as a result of that. So even if Ahmaud gained control of the gun, even if he put his finger on the trigger, even if he's the one who pulled the trigger, to me, it still qualifies as murder. You're creating a situation of reckless disregard for human life in which a death occurs. And to me, it's felony murder, because you were by conducting the citizen's arrest unlawfully. We have a name for that. It's called kidnapping. So if you're conducting a citizen's arrest when you can't, you're detaining someone when you can't, with force, might I add, that's kidnapping. So you're committing a felony. And someone died in the course of that felony that you created. So even if Ahmaud was the one who actually pulled the trigger and wound up shooting himself, it's still felony murder. It's felony murder because you're the one who created the incident that caused all this to occur. So that's where my legal analysis really differs from Robert Barnes. Even assuming that Ahmaud Arbery was committing a crime by going onto the instruction site, which I don't think he was, at least in a criminal sense. Was it civil trespass? Maybe. Criminal trespass? I don't think so. It wasn't posted. It's not someone's home. No one's living there. Even assuming he was casing the joint, for what? I don't know. What would you case a construction site for? Wood? I don't know. But it's not immediately obvious that there's a crime there. But even if he was committing a crime, it wasn't in the presence of these individuals. So they don't have the benefit of citizen's arrest. They're sitting in the middle of the road as Arbery is running up to them. They don't have the benefit of a citizen's arrest. Therefore, it's kidnapping. It's armed kidnapping. They're trying to keep someone from moving using force. That's kidnapping. That makes it a felony. He chooses to engage in force, in self-defense. That's his right to do so if he wants to. Maybe he gets a hold of the gun. Maybe he puts the trigger. Maybe he winds up shooting himself. Felony murder. So murder in the first degree. That's what I think is the best legal analysis. Now, there's other things that might be going on here. So to say, I'm not willing to say it is murder in the first degree. I'm not willing to say it is felony murder. But the idea that felony murder is off the table, I don't think so. If you want to say it's some other degree of murder, if you want to say it's manslaughter, we can have a discussion on that. But the idea that it's not a homicide strikes me as just completely incompatible with self-defense law, with everything I know about citizens arrest. It's just not something that goes on. So, I mean, that's what I see in the video. It's just not working. So, and even if it was a lawful citizen's arrest, I'm not sure that the use of firearms in conducting the arrest is allowed. Because for the same reason that police aren't allowed to use firearms to conduct an arrest, and I want to say that with some deliberation. They can't use firearms to conduct the arrest because that's the U.S. Supreme Court precedent. You can't use a firearm to stop a felon or to prevent a felon from escaping or things like that. You can use a firearm in self-defense if you're a police, but the mere arrest itself, you can't use a firearm for that purpose. And the idea that, and again, these aren't cops anymore because they're in their private capacity, so qualified immunity is out of the picture. So that's what I see what's happening. So I'll take some analysis. So Skip White is criticizing me in the channel. The dude in the video says knows nothing about the case. Well, I watched the video. Well, I'll tell you what I've done in order to reach my opinion. So I'll give you my bona fides on this. First of all, I'm a licensed lawyer in Virginia, not Georgia, but I can read a Georgia statute. I saw the shooting video, and I saw the videos of him casing the scene, and I've read some reports on this. So I have some knowledge on it. In terms of knowing the law, I quoted it to you. I know the law. I read it to you. It's section 17460. I don't know what more you want from me. I read it to you chapter and verse literally. That's what it says. That's not what applies. Self-defense law, pretty well established what you can and cannot do. You know, you don't have a self-defense claim for an incident that you start. So, you know, very good. Yeah, Georgia might have open carry, but they weren't carrying they were brandishing because the firearm wasn't in a holster. They weren't carrying it. They were brandishing it within the meaning of the law. So I don't think that's, you know, I don't think that's going to work. Yeah. Evil Triple says there's literally police tactics of felony arrest where they do nothing but point guns and bark orders. Yes, I understand. That's why I tried to say it with extreme deliberation. I was trying to say what I said with precision. Because you can't use a firearm to effectuate an arrest. Yes, they use firearms, but well, it depends what you mean by using firearms, right? They don't actually shoot them, so that's what's going on. Cornelia says, was it self-defense once he grabs for the gun? No, that's what I'm saying. It's not self-defense. No, absolutely not. It is not self-defense. This is a place where me and Robert Barnes split. Huge. If they were in the wrong in the first instance, then Ahmaud Arbery reaching for the gun is his self-defense right. Ahmaud has the right to reach for the gun in self-defense. But it then doesn't mean that because he's in possession of the gun, now he's armed. Even assuming that's true, it doesn't mean that the other two people now have a self-defense claim. Because they're the one who initiated the situation. That's where this is breaking down. So even if he became armed, even if he became an armed threat, The people who used lethal force did not have the right to use lethal force. They didn't have the right to self-defense, even understand your ground. They didn't have the right to self-defense because they initiated the situation that resulted in it. And that's a really big difference. Is holding a gun same as brandishing? No, but I think that with what they were doing and in the context of it, it qualifies as brandishing. We can look at the relevant brandishing statute if you want, but I think the same, it's holding is not necessarily brandishing, but when you're standing in the middle of the road and your car is standing in the middle of the road and you're standing in the middle of the road and you're trying to apparently effectuate an arrest, I think that's brandishing. Does brandishing require pointing at the individual? No, it doesn't require pointing it at them. No, that's too much. Brandishing does require intent. Yes, but it requires the intent to do the action. So that is, yeah. Laughing Daffodils, I think, has a better. You can openly carry a long gun. You must always do it safely. That's right. If you're going to carry a long gun, it has to be done safely. Pointing in a safe direction. That is not what was going on here. So, yeah. That's what I think. I don't think and Robert Barnes also challenged me. What would I think? I'll get to your question about 1713 4C in a second. I'll get to your question there in a second because I'll look it up. God, I lost my train of thought. All right, I'll look it up now because I forgot where I was going to go. All right, hold on. Let me look it up. And see if it does or does not in my best judgment. This is one of the things about that makes YouTube sometimes hard when you're trying to like do multiple things at the same time. It makes it hard to keep your train of thought because you have a lot of people talking to you at once. It makes it difficult to. All right, 17440, Georgia Code. 17440. Persons who may issue warrants for arrest of offenders against penal laws. Warrants requested by others. Persons who may issue warrants. Okay. Any judge or superior doesn't apply. If the application is made by warrant, doesn't apply. C. The person whose arrest is sought is incarcerated. No. 17440 deals with arrest pursuant to a warrant. It has nothing to do with this situation at all. 17440 is completely in opposite to the current situation. I don't see how it has any applicability to what's going on. Skip White says, Arbery initiated the cause of his death by charging the man with the gun. Yes, no. That's not how that works, Skip. That is not how that works. Okay? Let's break this down for Skip. In the small, easy to understand words for Skip here, okay? Let's make this really simple. I'm standing on the side of a street. I'm not doing anything wrong. You come up to me with a gun and you say, give me the money. I go for the gun. I have the right to do that. You're presenting an imminent threat of death or bodily harm because you're brandishing a gun at me and threatening me. You are committing an act that is presenting imminent threat of death or grievous bodily harm. That gives me the right of self-defense. I have a right of self-defense. Now, what I should do in this situation, who knows? I have a whole range of potential options. But let's talk about my legal options. One of my legal options includes attacking your ass with any force, with non-lethal force or lethal force. Either one would be fine. So if I happen to have a gun on me and I shoot your ass, that's self-defense. But if I don't have a gun and I try to reach for your gun, that's self-defense too. I have a right of self-defense. And if you're standing 30 feet away from me at the time, if you're trying to mug me from across the street, which is the weirdest mug ever, but if you're trying to mug me from across the street with your gun and point it at my direction, say, give me the money, and I run across the street and I try to tackle your ass, that's self-defense. I have a right of self-defense. So I, in trying to do that, am not initiating. You're initiating. You're the one who started this whole thing. You're the one who started the first illegal act in this whole wonderful chain of crap. You're the one who decided to pull a gun on me and threaten me or whatever, and I'm the one who's now coming back at you. And I get your gun, and then I get shot. Do you have a right of self-defense? Does the mugger have a right of self-defense? Hell no. Absolutely not. No, no, no. Absolutely not. That's not how this works. So if the citizen's arrest was improper, which I think it is, because 17440 doesn't apply because it didn't happen in their presence or with immediate knowledge. 17440 doesn't apply, so it's not a citizen's arrest. Therefore, it must be a kidnapping. It's an armed kidnapping because they're trying to stop him. That's what they're trying to do. That's a kidnapping with a gun. Incidentally, brandished or not, it's still armed. Even if you have the gun on your presence, even if it's not exposed, it's still armed kidnapping. We've seen people get convicted just because they had a gun on their person, even if it never got used, as being an armed crime. So if 17440 doesn't apply, it's an armed kidnapping. That's a predicate felony. It creates a grave risk of death. That gives me a self-defense right. I come up to you. I try to seize your shotgun. I get a hold of the shotgun. My hand gets on the trigger. I wind up pulling the trigger. I wind up shooting myself. You're guilty of felony murder because you're the one who started this rodeo, not me. So you're just completely wrong. Totally wrong. Yeah, 17440. Apologize. That was the wrong statute. I apologize. I was quoting the guy from earlier. I apologize. 17460. That was my bad. 17460 was my mistake because the other guy had quoted me 40 and I was quoting back 60. I apologize. 17460 is the citizen's arrest statute. I will put it in the link so you can go see it yourself. You need a cool background? I think my house is plenty cool as it is. Thank you. Yeah. I'm trying to ask what the Fox Flame says. I'm trying to ask what they were doing that was illegal in Georgia before he stopped. Well, attempting to stop him would be qualified as armed kidnapping. So assuming they said anything like, hey, you stop, or anything that would be resembling that, that's armed kidnapping. That would work. Also, I'd argue, even without them saying anything, by attempting to block the street, that would qualify as an armed kidnapping. So if they said anything, armed kidnapping. Even if they didn't say anything, by being in the middle of the street and trying to physically block him, which seemed to be what they were doing, that would be a armed kidnapping. Yeah. Yeah. Again, Dave, assuming whether or not Ahmaud Arbery was committing a crime is a little bit off point in terms of whether or not he was going onto these construction sites or whatever. 17460, which is the statute that deals with citizen's arrest, requires a citizen's arrest to be done in your presence or with your immediate knowledge, is the phrase that Georgia uses. So you either have to see it happen or you have to have a live report from someone who saw it happening. The idea here is, again, the idea here is that you're walking down the street and a shopkeeper pops his head out and says, stop that man, he stole from me. That would be the kind of thing that the statute is talking about. That would be the kind of thing that gives you immediate knowledge. You didn't see it happen because you're just walking down the street. The shopkeeper comes out and says, stop that man, he stole from me. That would be the kind of thing that gives you immediate knowledge. That you are vaguely aware that there is an individual who in the past has gone into many construction sites in the past, including recently, does not qualify. That's not what the statute is talking about. So, I think felony murder looks pretty good. Now, to the next question of whether or not it's a hate crime, let's talk a little bit about that. Yes, I saw the video inside the house. Yes, I saw the video inside the house. Yes. I don't think it was illegal. And even if it was, it doesn't matter. Because 17460 doesn't give the power to arrest for video. How did they see this? How did the people who conducted this arrest, how these two individuals who conducted this arrest have knowledge of that video at the time they conducted the arrest? Because we're going to what they knew and what they didn't know. That's the operative question. We're going to what's in their state of mind at the time. What did they know and what didn't they know? Did they have access to that video at the time they conducted the arrest? No? Then it doesn't exist. It doesn't exist as to them because it's not within their knowledge space. Doesn't matter. We're only interested in what they knew and what they didn't know. If they didn't know about it, doesn't matter. That video is super, super interesting. Doesn't matter. It's irrelevant. And again, even if they knew about it, was it a live feed? Are you telling me that these two individuals who were trying to conduct this citizen's arrest using a shotgun, are you telling me that they had access to a live feed from the construction sites? Yeah, that's what happened. They had access to a live feed and they were watching it in real time. And that's how they had knowledge of it happening. That's how they had knowledge, because they had access to a live feed from the construction site. If that's what you're telling me, then we'll have a different discussion. But short of that, I don't see how any of this applies. I don't see how any of that applies. They were next door? Okay, great. And therefore what? So what? Okay. What did they see? They were next door and they saw it in real time and they decided to go down. What are you trying to tell me? It doesn't make any sense. It doesn't make any sense. It doesn't make any sense. It doesn't make any sense that they knew about it at the time. We're concerned about what they knew and what they didn't know. Georgia case law supports citizens' arrest for reasonable suspicion. Yes, it certainly does. You don't even need the case law for that. You can just read the statute. Barnes is right. It's in the statute. You don't need case law. It's right there. 17460 says you may arrest him for reasonable and probable grounds of suspicion, but only if there's a predicate. Only if there's an offense committed in your presence or with immediate knowledge. So yes, reasonable and probable grounds of suspicion is right in the text, but there is a limitation. All right, so is it a hate crime? Probably, I don't know. In order for it to be a hate crime under federal law, they would have to be doing it because of a protected reason, because of race. Their motivation would have to that they were committing the crime because he's black. And we don't have enough information to reach that conclusion at this time. There's insufficient evidence at this time, in my view, to conclude that this is a hate crime, because you can't show the intent, or apologize, not the intent, the motivation, because it's one of very few times in the law that motivation is actually relevant. That's why I slipped up, because motivation is almost never used. This is one of the few times. There's insufficient evidence to show the motive for this was race. And because that is missing, it's insufficient at this time to show a hate crime. So the feds are going to be investigating, I'm sure, and they're also going to be investigating the activities of the police department, which are more interesting to me. So I don't really care so much about the federal government prosecuting this or not in terms of prosecuting the murder. I'm much more interested in them in terms of them investigating the police apparatuses, which, the federal government Constitution does require the federal government to guarantee to the states a Republican form of government. So they can go and investigate and see whether or not that was happening. But it seems more probable at this point, to my mind, it seems more probable at this point that this is vigilantism gone wrong. This is vigilantism gone wrong. It seems to me at this time that you have a bunch of individuals who are concerned because an individual who's going into construction sites a lot, which again, I don't particularly know why that's in and of itself concerning, because when I was a kid, I went into construction sites a lot. I like construction sites. I think they're cool. I like seeing seeing the mechanism of all and how the pieces go together. I mean, I'm not a carpenter, but I still think it's interesting. I like mechanical watches for the same reason. I know I can't build a watch, but the gears moving and all that mechanical stuff is pretty cool. And so seeing all the mechanisms, seeing a house, and it's interesting to me because I'm sure I'm not the only one who has this issue. But when you see a house completed, it's hard to remember at least to me, that it's made up of components. It's hard to remember that it was built because you just see it as this abstracted whole, the house. And so it's kind of nice to see, oh, that's right, houses actually have to be built, and they're actually made of pieces that have to go together, and how they're actually constructed. I think it's kind of cool. So it's interesting how those pieces come together to form the whole. Same thing with like a firearm. If you've ever taken a firearm completely apart, one time I did it just for the hell of it, because a Glock, for example, which is my pistol of choice, only has like 43 components. So one time, just for the hell of it, I actually took the gun completely apart. I actually removed every component I could, just to, as far as it could go, just to see how it's interesting. And it's really fascinating because you have these little tiny pieces and these little tiny springs that look like nothing, and yet combined they form the entire thing. So that's pretty cool. So I'm not sure going on the construction site in and of itself is criminal. Is it a civil trespass? Sure. I'm sure it is. It's got to be someone's property. But is it a criminal trespass? Probably not, unless it's posted, unless there's a fence, unless there's something more. I don't think so. So, I don't think it's criminal, the trespass. Now, whether if he was committing a crime on the construction site, yeah, maybe. But I don't think the mere going on there is criminal. Would be my thought. And even if it is, wow. Patrick Newton wants to get banned, apparently. Patrick Newton, who says University of Southern California, I assume, over Clemson all day. Wow. No. Thank you. But no. I don't see this. So I don't see Robert Barnes' point. And he's a very smart lawyer, but I think he has this wrong. I think that the statute for a citizen's arrest doesn't apply because they didn't have the knowledge requisite. Even if they did, I think they acted with too much force. I think that they became a criminal kidnapping. I think that because they initiated it, he had the right of self-defense. And even assuming, as Robert Barnes seemed to suggest, Robert Barnes was like, well, maybe he grabbed he was trying to grab a hold of the gun. Well, that makes him an armed individual. I'm like, well, even if that's true, Robert, who cares? Who cares? No one cares. Even if trying to reach for the arm makes him an armed person, it doesn't matter because the other person started it, so they don't have a self-defense claim. Oh, he's suddenly armed. I can use self-defense. No, that's not how any of this works. That's not how any of this works. So, yeah. I mean, I've been on construction sites that are more completed than others. So, I've been in houses that are pretty complete, but are still in the construction process. So, again, even assuming that's a criminal action, which I'm not sure it is, because no one lives there, it's no one's property. I mean, someone's property, but no one lives there, so it's no one's house yet, in that sense. So, I don't know. It's a felony to trespass onto a construction site. I'd have to look at the statute. But again, even assuming it's a felony, I don't think it gets you where you want to be. So that's what I think. Anyways, I want to thank the individuals who are here. Your argument makes all armed individuals who claim self-defense the aggressor. No, that's not how that works. Your argument makes all armed individuals who claim self-defense the aggressor. No, that's not how that works. That's not how any of this works. What are you talking about? Are you not paying attention to what I'm saying? Let's try this again from the square one. Okay. Self-defense law 101. You can only use self-defense in response to a threat. In order to use lethal self-defense, you have to be presented with a lethal threat. A lethal threat is defined as an imminent threat of death or grievous bodily harm. That's a lethal threat. All right. Now, if a person is presenting a non-lethal threat and you respond with lethal force, you are in the wrong. Because although you have a right to self-defense of a non-lethal nature, You're responding with lethal force. So now you are the initiator because you have moved it beyond the scope of where it was. Okay? It was non-lethal, you have moved it into lethal. Right? So now you're the initiator. However, if the other person starts, well, even with non-lethal, if at some point whoever makes the first move to lethal, whoever makes the first move into lethal force loses. Okay? Whoever makes the first move into lethal force loses. This is how we do this. All right? So you have two people, one starts with non-lethal force, the other person responds with non-lethal force. We have a non-lethal force to non-lethal force interaction. The second person is protected because they're responding in self-defense. But it's a non-lethal interaction. Whoever responds with lethal force first loses because you've moved beyond the scope of self-defense. You only had a right to use lethal force in response to lethal force, which didn't exist. So whoever makes that move first loses. All right? Because you're the one who initiated it. All right? So if you start by pulling out a gun on me, you've created lethal force. That gives me the right to use lethal force against you. So I can pull out my own gun and shoot you, or I can try to take your gun away, or whatever. I now have the right to act. And if I pull out think about what you're saying. Think about it logically. You pull a gun on me. I don't have a gun, but I have a knife. I'm a knife guy. I'm Crocodile Dundee. You pull a gun on me. All right? You're the first to act. All right? I now pull out my big ass knife and I'm about to come for you. And you say, he's got a knife, and he shoots you. You think that's self-defense? You're out of your mind. You're out of your mind. You're the one who started this rodeo. Oh, he has a weapon now. Yeah, in response to the situation you created, you jackass. Curtis Jones says, can you post a cut of that thing you did yesterday with your favorite case? It will get cut and will get posted eventually. That was my batch recording session. So all that stuff gets cut and posted eventually. It will get cut and posted eventually. So, yes. Yeah. Ooh, you could blow the case wide open if you want. Ooh. Neo-Epicurean says he can blow the case wide open. Ooh, wow. Okay, Neo-Epicurean. What you got for me? This will be good. Why don't you, as the person who wants to somehow Google Maps is going to make this all make sense. Sure, let's go with that. Georgia code 1671. Let's see what we got there. A person commits an offense of burglary in the first degree when without authority. Okay, so yeah, a person commits the offense of burglary in the first degree when without authority and with intent. So this is notable, with intent to commit a felony or theft therein. So you also have to have an intent to commit a felony or theft in the property. So that's a predicate. So merely entering a property isn't enough. You also have to have this subjective intent. Okay, but you have to enter or remain in an occupied, unoccupied, or vacant dwelling house of another, or building, railroad, craft, or such structure designed for use as a dwelling of another. Well, again, you'd have to get into when exactly that happens in terms of a house being constructed. Because an occupied, unoccupied, or vacant dwelling house, or any other building or structure designed for use as a dwelling of another, I guess you might have to have a philosophical question in there somewhere as to how complete a house has to be before that would qualify. How complete does it have to be? I don't know the answer to that question. I'm sure there's really interesting state law interests on that and trying to determine how complete it has to be. But I don't think let's just say that I don't think a construction site that's not at least 51% complete qualifies under this section, because I don't think it qualifies as a dwelling house of another if it's not at least majority complete. So we can have some philosophical questions on that, but I don't think burglary quite works for a construction site. I don't think that works. Yeah. Oh yeah, roaming rights are interesting in the UK. That's an interesting difference between UK law and US law, is that you have the right, and I don't begin to understand this on UK law, so don't take anything I say as gospel, but you do have the right to generally cross people's land, even if it's private, because of long existing rights. Neo-Epicurean still, okay. Avery shot 200 yards from Larry English's house. Okay, and therefore what? After a 6 minute car chase. Okay. He shot 200 yards from Roy English's house. Okay, and therefore what? I'll just take your word as I'll just take it as given. I believe you. You don't have to show me a map. I believe you. He was shot 200 yards from Larry English's house after a 6 minute car chase. Okay, and therefore what? I believe you. So what? $10 from Phoenix Sun. Thank you. Good evening, sir. I enjoy your commentary. Thank you very much. I'm currently studying for the July LSAT. Okay. I plan on joining your legal profession within the next 4 years. Okay. My recommendation to anyone planning to go to law school is that you should have a very, very good idea of exactly what you want to do with it before you start. Because there is a bimodal distribution of income on lawyer salaries. There's a lot of lawyers who make $60,000, $70,000 a year, and a lot of lawyers who make quite a bit more than that. You want to have a pretty solid idea of exactly what you want to do before you spend the money that law school is going to incur. So my recommendation, and if it would be advisable, if at all possible, to get an internship. I mean, even if you have to work for free for the lawyer, it would be worth your time. Why? Because if you spend 3 months, say you want to do big law, just as an example. If you spend 3 months working for free in big law, even getting someone's coffee every day, you have a pretty you'll have a much better idea of what that profession looks like than you would when you start. It would be advisable to you to try to get a pretty solid idea of exactly what that looks like before you start. So that would be my recommendation. That'd be my recommendation. Yeah. Yeah, I'm not sure it's burglary. I'm not sure it qualifies as a dwelling house if it's under construction. I'm not sure at what point exactly it becomes a dwelling house, but it's not obvious to me it's burglary. Also, you'd have to have, again, merely entering and staying there isn't enough under the statute. You still have to have the intent to commit a felony while also doing that. So, what that would be in the case of a house and no one lives in it and there's no property, I'm not sure, but okay. Yeah. Any advice on choosing between different fields of law? Mm, mm. My recommendation there would be talk to a bunch of lawyers in different fields. Um, Again, you want to look at the economics of it in particular, because a lot of fields don't pay as much as you think it would. There's a lot of legal fields that don't pay very well, so you want to look at the economics of it and try to figure out what you want to do. Um, I kind of wish at this point I had become a criminal prosecutor out of law school. I did the juvenile division, which I didn't really like, but yeah. So, yeah. So I think All right, so we got some more commentary from Neo Epicurean. Let's read some commentary from Neo Epicurean. This is exciting. Let's see how far back we want to go into this commentary. So he said Larry English's house is at a particular address. Okay. He shot the intersection of Holmes and Stelia. Fine. 30 seconds away. Great. What? Okay. That's fine. And therefore what? The 911 call is made at a particular time. Okay. He's running back at them. Well, he was running towards them. That's for sure. They chased him down to Zellwood and then drove back outside their own house 50 yards away. And Ahmaud came running towards them. That's when he calls 911. He's panicking. He says, a black guy running. He means running at me. Well, a black guy running at you does not give you the right of self-defense, because even assuming that qualifies as a threat, is it an imminent threat of death or grievous bodily harm for a guy running at your direction? No, it is not. There's a guy running in your direction. That gives you the right to shoot someone? I don't think so. Arbery gets to the truck. It's still a 911. It's captured on audio. He's screaming at Arbery to drop it and referring to shotgun. Okay. Whether or not Arbery got a hold of the shotgun, I don't think matters. Whether or not he pulled the trigger, I don't think matters. If he had the right of self-defense, it doesn't matter. So he's running towards them. They have shotguns for some reason. Okay. Who expects an unarmed man to run 200 yards and launch an attack on two armed men? Well, if those armed men are posing an imminent threat of death or grievous bodily harm against you, you have a right of self-defense. I don't know how to explain this to you in any smaller words, you idiot. I don't know how to explain this to you. I've explained this to you 4 or 5 times at this point, but you're just not getting it through your thick skull. So let me try again, you dumbass. Let's try this again from square one. All right? You don't have a right to shoot someone just for the hell of it. There are rules. If you're posing an imminent threat of death or grievous bodily harm, a person has a right to run 200 yards and try to steal the shotgun from you. That's a thing a person can do. It's within their legal rights. And if they try to succeed, you can't then claim, oh, they have a gun now, and I feel scared. You're the one who started this party. Someone running in your general direction does not qualify as an imminent threat of death or grievous bodily harm. You want to say that the 2 people who were standing in the middle of the street with their guns had a right to use those guns because they were under a threat. Well, in order to use lethal force, as I explained several times, you dunderhead, in order to use lethal force, you have to have an imminent threat or death or grievous bodily harm. Here's my question to you. How does an unarmed black man running in your general direction qualify as an imminent threat of death or grievous bodily harm? How is that a thing? How is that qualifying as a lethal threat such that you would be justified in self-defense in using your gun? Yeah, you have any thoughts on that one? No? Okay, then shut the hell up. You know what, Neo Epicurean? It's my channel, and I will call you any damn thing I please. How about that? I will call you any damn thing that pleases me. How about that? Suck on it. It's a nice thing about being the channel owner. The rule about not insulting people doesn't apply to the person running the channel. It's nice. So, for the 116 of you who are here, I want to thank you very much for being here. I disagree with Robert Barnes. I think he's got the analysis wrong. And again, we are nowhere near the end of this thing. So the facts, as they further develop, may change. We're nowhere near the end of this thing. Okay? I was very clear at the start of this thing that I don't think that any conclusion can be drawn. I think Robert Barnes is wrong in the way he's analyzing this. That I think, given the evidence we have right now, that looking at this as a homicide charge of some variety is more probable than not. I think that this qualifies as some kind of homicide. I think felony murder looks likely because I think the armed kidnapping as a predicate works. Because I don't think it's citizen's arrest, because I don't think 17460 applies. But things might become developed differently. And maybe as things become differently, and maybe as the case becomes more developed, it will become more apparent that the facts are not as they seem right now. So, I mean, both sides, everyone's entitled to the day at court. Everyone's entitled to a defense. And it may be at the end of the day that these people didn't do anything wrong. Maybe they are within the bounds of the law. But given the evidence we have right now, I don't think that works. Q Squared says, I consider myself fairly left-leaning. You consider yourself fairly right-leaning. We seem to agree on 90% of cases. I don't know what this says about anything, but fair enough. Yeah. I don't know what this says about anything else. Yeah. So maybe Neo-Epicurean will, in the end, be proven right. It could happen. It could totally happen. I just don't think, given what we know right now, that seems particularly likely. I don't think that, given what we know right now, again, because we're well early in this, so a lot of things can happen, but they don't appear to be able to use a citizen's arrest. They appear to be blocking the road. They're blocking his right to travel. All the sovereign citizens like the right to travel, right? They're blocking his right to travel. Using arms. Seems to be potentially an armed kidnapping, seems to be like felony murder. And maybe it's not felony murder, maybe it's something else. Could be manslaughter, could be a lot of things. I don't know. I don't think it's a hate crime. We don't have evidence for that yet. It seems to me a couple people went off the rails and went into a vigilante mode, and it seems to me they're guilty of murder, and it seems to me that they're going to jail for 10 plus years. But we're nowhere near the end of this. Can I get a jury to convict on those charges? Yeah, right now, I think so. But we're well early in the process. We have to hear a lot more testimony. But yeah, if the jury is charged this was Robert Barnes' thing. Like, if they're charged properly under the law, yeah, I think so. Beyond a reasonable doubt, yeah, I think so. Because the questions we're trying to raise are legal issues, not factual issues. Like, the facts are a little bit in dispute, but not that much in dispute. Like, the operative questions we're trying to reach are legal, not factual. So I'm trying to determine, I mean, there are some factual issues in dispute, make no mistake, but like the legal implications are different. So in terms of like a jury finding the facts beyond a reasonable doubt, yeah, I think so. That's the issue we're trying to get to. As to what those facts would mean legally, that's for the judge to charge as per the instructions. So that's part is not beyond a reasonable doubt. That's part is just like, well, here's the mechanical aspect of it. Here are the facts. Here's what happened, and here's the operation of the law. $8 from Willie Czar. Please comment on how police handled it. It looks to me suspiciously like what it seems to me is one of these people is former police, and the thin blue line goes deep, and the prosecutor did essentially one of his boys a solid. I don't know that I'd go so far as to say it was malicious. I think it's just more part of the mentality of the thin blue line and giving his bro a pass where he wouldn't do that to someone else. I think he looked at it with those blue tinted glasses, and I don't know that was necessarily malicious. I just looked at it and said, but we'll see what happens. Now, you can't go for a directed verdict in a criminal case. You can't do that. You need to get a jury. So you can't do a directed verdict in a criminal case. Not for guilty. You could for not guilty, but not for guilty. No, Matthew. You can't get a directed verdict in a criminal case for guilt. No. You can't get a directed verdict in a criminal case. No. Not for guilt. For not guilt, you can, but not for guilt. You can't get a directed verdict. No. Anyways, that's what I think happened. So I'm going to cut the stream off. This was a lot longer than I anticipated it to be. We're here an hour. I didn't think it was going to be this long. Yeah. Matt, no, Matt. Okay, Matt, you can just add this to the list of things. You can't get a directed verdict of guilty in a criminal case. Criminal and civil law are different things. The Copyright Office is not part of the executive branch. We're just going to create a list of things. $2 for Phoenix. This has been your daily Matt Slapdown. Yeah, a little bit. Oh, man. We love Matt. Thank you, Matt, for the GoPro, by the way. He sent me a camera, so as soon as I get the cables and stuff, we might get a better webcam, or we'll see. I'm going to head off, guys. Love you all. Peace. Bye.